Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, welcome back. We are with attorney Jeff Roberts out of Murray, Calloway County, and he also has an office over in Hopkinsville, over in Christian County. Today's topic is going to be kind of interesting. I hadn't thought about this one, but the question is, can you sue the state for negligence? Jeff, welcome to the studio, guy.
Morning, Jim.
Good to see you. So negligence obviously is something you've got to prove as an attorney if you're going to bring a case. But when you're dealing with the state or the county or the city or the municipality, things get a little bit complicated. It's not as easy and cut and dry, is it?
It is not as easy, and it's hard to explain to some people that have been injured because of negligence that unfortunately there's not much that you can do from it to rectify it from a legal standpoint. Can you sue the state? Yes, but there are limited ways that you can do so. The Commonwealth of Kentucky enjoys sovereign immunity. County governments also enjoy sovereign immunity, and agencies thereof also do as well. So like the County Board of Education has sovereign immunity. So the way that you can sue them is going to be very limited. There is a limited waiver of sovereign immunity that allow you to go to the Kentucky Claims Commission that we're going to talk about here in a little bit. But normally the way to try to get around sovereign immunity and the inability to sue the Commonwealth or the county governments is to sue the employee directly. The employees have what's called qualified official immunity. They're not sovereign immunity. They're not the government, but they are obviously agents of the government from that standpoint. So they have some immunity, but in certain situations you can sue them for negligence. One quirk to Kentucky law is that it's the Commonwealth and counties that enjoy the sovereign immunity. Municipalities or cities do not have that same protection from lawsuits there. So, if it is a city employee, if you've got a city employee that's driving down the road and runs a red light and hits your vehicle, then you can sue them without having to worry about that employee having any type of official immunity or the city having immunity from that standpoint. If it's a county road department employee, for instance, then the county would have the immunity, but you could go against the road department, the individual employee from that standpoint. But assuming you can get around the qualified official immunity.
That makes sense. And let me back up for just a second with you. The idea of sovereign immunity, kind of what is it and why is it there?
Sovereign immunity is something that has existed for centuries. And even before the United States was a country, sovereign immunity existed. And sovereign immunity, and frankly, it kind of gets its name, I'm assuming, to some extent from kingdoms, where you had the sovereign who was over the king, over the territory. And it's basically you can't sue the king. The king is immune from lawsuits. And that's been kind of down through the ages. Governments have to govern in some form or fashion. And so they enjoy this immunity, and the only way to be able to pursue a claim against them is if the government has waived the immunity. If the Commonwealth, the United States itself has immunity as well. It enjoys sovereign immunity. Commonwealth of Kentucky has sovereign immunity. Every state enjoys their own sovereign immunity from that standpoint. And then the county governments also in Kentucky have sovereign immunity.
Okay, so it's that level of protection that just stops the entity itself from just getting pounded by lawsuits. Some of them with merit, some of them maybe without. It's just people who feel disgruntled. So it's kind of a filter or screening system, I guess.
Well, exactly. I mean, you've got, the government to govern has to make certain decisions, and unfortunately, sometimes when they make decisions, some people may suffer a little bit and others benefit from it, and that makes that can make a difference. And so but they've got to make a choice. Like, where's a road going to go? They got to have a road at some point in time where it's going to go, and whose land is going to be taken, and whose land is going to benefit from having the road close by or whatever. Those are decisions that the government's got to make, and it allows them to make it without being sued and being tied up in court all the time trying to figure out all of these things.
That makes sense. And then it comes down to, again, were the employees who were executing that plan, were they negligent? And if so, maybe there's an opening there.
There may be an opening. Even sometimes when they are negligent, there is not, you cannot pursue a claim against a state employee or a county employee if they have qualified official immunity that I mentioned earlier.
Yeah.
And those, it kind of comes in, it gets very, very complicated and very hard to determine at times. You come down to looking at whether the act is a ministerial act versus a discretionary act. If it's a discretionary act, even if done negligently, there's still immunity.
Could you give me an example of what that is?
A discretionary act versus a ministerial act is whether the road department salts a road before a snowstorm hits would be discretionary. If they know there's going to be a rainstorm coming beforehand, they can choose not to put the salt or the brine down on the road beforehand. Discretionary with the road department on whether they do that or don't do that from that standpoint. But they have to obey the laws of the road. So if there is a stop sign and they run the stop sign, that's not discretionary. You stop. So that's going to be more of a ministerial duty from that standpoint. And so those are ministerial is something that you've got to do. It's it's
You're
not
required to.
Yeah, you're required to do it. There's no discretion on your part. In discretionary, obviously, there is discretion on whether whether the person takes that action or doesn't take that action.
Yeah.
So
As we were talking about this in preparation, most of the time I was thinking about the Department of Transportation, Road Works, and those kind of departments is where this might come in. But there's I guess a lot of other places this could actually happen because so much of the buildings we go into, so many of the different areas where we're going to interact with the government, whether we maybe realize it or not. So.
true, and one that kind of because you look at the rules that the department has in place or the county or whatever has in place. Some of them are like you stop at a stop sign are statutory, but some are the policies of the agency itself. For instance, one could very well be, if a police officer stops somebody who they know and they can tell and they suspect they are very drunk, and they don't arrest them and don't take them off the roadway. The police department policies may be if they fail the field sobriety, they are, even if they refuse to do a breath test, then the officer is to arrest. If they show so many cues or whatever it may be, then you arrest in that situation, and that's part of the police department or sheriff's department's policies and procedures. And so if the deputy fails to do that, he had an obligation under the policies and procedures to act in that situation, and it wasn't discretionary. Whereas if he stops somebody for speeding, whether he writes a ticket or gives a warning is going to be a discretionary act in that regard. So on the DUI, the person driving drunk, I'm not saying an officer would allow somebody driving drunk to take back off again, but using that as an example, if they did allow them to get back behind the wheel and then, half mile down the road, they cross the center line and hurt somebody, then you could potentially sue not only the driver, but the police department, the sheriff's deputy that allowed that person to get back on the road if the procedures was you don't do that. You see it, it's playing out a lot now in the court system in regard to high-speed pursuits. And when they can be, because a lot of departments have have policies on whether you can engage in a high-speed pursuit or not. Sometimes you may have to go to the CO and let them know the situation. And if it's somebody who's, the reason you're going after them is speeding, and they're coming in, let's go with Louisville as an example, which is where you're located at. If you go with Louisville as an example of you're speeding down, if you got somebody speeding down one of the roads in Louisville that is a lot of traffic on it, and the officer, and the only charge is they've been speeding, then the policy may be, look, they're in danger, and if they're going 60 mile an hour down these city streets, they're in danger, and everybody around from that standpoint, we need to break off, and so we don't put these folks in danger. Whereas if they are out on the West Kentucky Parkway and there's no traffic around, then you would go ahead and continue in a pursuit in that situation, and it's going to depend on what the policies and procedures are, but there's been a lot of people that have been injured because of high-speed pursuits. And, if it's a fleeing felon, somebody just committed a bank robbery and they're fleeing, then the reason for pursuing that, or, they committed a violent crime, there's a different reason, and you have a different policy on pursuing those individuals at a high speed versus someone who just was going 10 miles over the speed limit, and then you got behind them and they took off. Then there probably is a reason why they took off, but the only crime that the officer's aware of is the speeding at that point in time. So a lot of times policies say you break off in that situation instead of putting citizens, innocent citizens' lives in danger.
I could see that especially around a school or maybe a hospital or something where, hey, look, there's a lot of people here, like you said, a lot of congestion, and it'd be better not to provoke it.
Correct.
So let's slow down and maybe call ahead, have somebody else up, a few miles
Yeah,
out.
and if you've got the license plate and all of that, you can usually track them down to some extent from that standpoint. And if the car, a lot of police vehicles now do have the dash cams and others that they can document their proving who was driving may be a little more difficult in that regard. But frankly, I'd much rather somebody who was speeding 10 miles over the limit get away than a kid getting out of school get run over by a high speed because of a high speed pursuit.
The risks are too great.
Correct.
That makes a lot of sense. But again, what you had said specifically is you have to come back and sue the officer himself or herself. You're not suing the police department. You're suing that individual.
Correct.
And that's part of that qualified official immunity.
Correct. That's part of the qualified official immunity. There, the individuals have some immunity, but they don't enjoy the same immunity as the Commonwealth or as the county does or as the agency itself does. So suing the individual deputy is different than suing the sheriff's department. Now, frequently, and frankly, to some extent, I think they ought to look at changing the rules around or laws around in regard to the immunity aspect of it, because frequently the county has purchased insurance, and that's who pays if it's the deputy is found at fault, then the insurance that the county has purchased should do that. In my opinion, the purchasing of insurance should be in and of itself a waiver of sovereign immunity.
It should pierce that protection.
It should automatically up to the level of that insurance coverage anyway, because frankly, if the county purchases insurance coverage, while they do have protection from they do protect the individuals, but when they purchase that insurance coverage, in my opinion, shouldn't matter whether it's discretionary or ministerial in that situation. If they're negligent, they're negligent, and the citizen should get that's injured should be able to get compensated up to the level of the insurance coverage from there, because frankly, you had a lot of counties that were purchasing the insurance, and then the insurance company was arguing sovereign immunity. And so we don't have any liability, and we shouldn't have to pay out any of our insurance proceeds. But that they were perfectly fine taking the premiums
Exactly.
in that regard. And if they were taking premiums, and taking taxpayer money which is what is being used to pay those premiums, then they should be providing the coverage. Because frankly, a lot of times, at least there for a while, they were getting premiums without having any exposure, and that shouldn't, in my opinion, that shouldn't be allowed.
Wow.
But unfortunately, the law hadn't evolved in that regard just yet, but hopefully it eventually will get there.
Because I mean, ultimately, if you and I are in a car wreck, let's say I'm negligent, I T-bone you at an intersection, you're not suing me necessarily. You're actually going up against the insurance policy that I'm covering at the time. So it's really kind of the same thing.
Exactly, it's very similar. If we file suit, you're the named defendant in the suit, but your insurance company pays, and that's the same there. Even though I'm suing, I may be suing a deputy so-and-so for that negligence. The insurance company is still the one paying, not the individual deputy in that situation from that standpoint. So to me, and frankly, it ought to be, the other reason for that is because when you do that and sue the individual deputy, even though the insurance is paying, that can be traumatic to the deputy who's out there and their family when they find out about that, because it may take a while before they realize, hold on, okay, I've got the insurance coverage that's protecting me from that standpoint. So flipping it around so that you're protecting essentially, you're not, the insurance company isn't getting premiums for nothing without providing any coverage, and the agency's the one that's the defendant, and you're not having the individual deputies and causing undue stress for people, from that shouldn't be there. And then the injured party is getting taken care of as well. And that's what, my ultimate goal is to make sure. Now, there are certain situations where immunity is waived. Workers' compensation, for instance, as you and I've talked before, I've actually represented several police officers during my career who've, sheriff's deputies who've been injured in the line of duty. From that, there is a waiver of immunity for workers' compensation purposes. And then I mentioned earlier the Claims Commission. The Commonwealth has waived immunity for negligence against the Commonwealth up to a certain amount in certain situations, which is you bring the claim in the Claims Commission. It used to be the Board of Claims. In a reorganization a few years back, they changed the name of it from the Board of Claims to the Claims Commission, and a few other changes in regard to procedure, but most of the stuff stayed the same substantively. And they've waived up to $350,000, so you're capped at $350,000 regardless of the total damages the injured person receives or the family receives. And then you've got and pain and suffering is not recoverable. It's the medical bills, lost wages, those type of things that are.
Wow. The
The biggest problem is also they get credit from any other payment. So if health insurance is paid, the medical bills, they get credit for what the health insurance is paid. So that $350,000, and it comes out of the $350,000. So if health insurance is paid $100,000, then the $350,000 cap is now down to $250,000. So while there is a limited waiver under the Claims Commission, it's very difficult to pursue those type of claims because of all these other avenues or other things that reduce what you can recover and limit what you can recover in those cases. I've been involved in some in the past in the Department of Transportation, actually the most recent one over some signaling at an intersection. And, though it's just very, very difficult to pursue those claims because, a lot of times once you take out what's others have paid for it, you're left with very, very little that you can ultimately recover.
So let me come back to the numbers example, and I always love doing numbers on a podcast where everybody's like, "Oh, wait a minute."
Yeah.
So if they're capped at 350,000, and let's say you had 100,000 in medical, so the states, now their liability drops down to that 250. Does the hospital or the medical provider, do they still have the right to recover that 100,000 out of that, or is there still a lien involved somehow? And this
I
may be
don't.
more technical than we want to get into, but I know in car wrecks and stuff like that, you've got to be concerned about the healthcare lien if the healthcare pays for it. They're right. They have a right to recover that.
Yeah, the one that, in my opinion, they do not, because to have a claim, you have to be able to recover it, and we can't recover that money from the state in that situation. So I would argue strongly. I'm sure it's been addressed. I've just never had. I've never personally had to look at it and research it. So I'm not going to say absolutely this is the way it is. But my expectation is they would not be entitled to subrogation or reimbursement because we didn't recover that money from the Commonwealth. The Commonwealth specifically said we don't get to recover those funds from them. If somebody else has paid it, we can't recover it from the Commonwealth. Where reimbursement comes in is when we've recovered that same damage that the health insurance has paid, we recover that from the at-fault party. Well, then the health insurance gets reimbursed because the bills they paid, we've recovered from the other side, instead of our client getting to get double recovery, health insurance paying on one hand, and then they get reimbursed.
Right.
We have to reimburse the health insurance at that point.
But because there was no payout, I guess at that point, there's nothing for the health insurance company to come back on.
Correct. If the medical bills have been paid by the health insurance, then we can't claim those in the claims commission.
Wow, unbelievable. So is the insurance company just out at that point? I mean, in terms of the funds that they're...
In my opinion, yes.
Yeah. Interesting.
Yeah.
Okay. So could you give us an example of a situation that may go in front of the claims commission? I mean, would this be, for instance, a police officer involved in a wreck or a first responder of some
Could
sort?
be.
Or
Certainly could be a police officer who is responding to a wreck or responding to something, but doesn't put their lights and sirens on, and they run through a stop sign. You could potentially sue them, but you could also sue, they may or may not have qualified official immunity. You could also sue the, if it's a state trooper, you could sue the Commonwealth of Kentucky, and that would go in front of the claims commission. The one that I mentioned earlier was, I won't go into the intersection itself, but it was whether the road department should have put up a protected left turn signal at where two 4-lane roads intersect, and there was a left turn lane on every one of the intersecting lanes there, and at one point before we filed the suit, it was if it was green to go through the intersection, then you could turn left if the traffic was clear. And there had been, in the case that I handled, there had been several wrecks where vehicles were turning left and the car come through and hit because there wasn't a signal in front of the turn lane at all. So you had the green lights over here.
you just had to guess.
And, it had on it the thing, yield on green or something of that nature. I can't remember a sign up there, but at 11 o'clock at night, out where this intersection wasn't lit up very well. A lot of people were turning, and there was wrecks there. In fact, in my litigation, a person who lived close by had complained multiple times that they needed to do something, and so we. There was a lawsuit over the wreck itself, and then also we pursued a claim, or I pursued a claim on my client's behalf against the transportation cabinet in the claims commission from that. There's no individual person like you have with a sheriff's deputy or a road department employee who runs a stop sign or something of that nature. These are, this isn't an individual determination. This is somebody in the headquarters making these kind of decisions, or at least the district office from there. And so there wasn't really an individual employee that was negligent to sue for qualified, that we could potentially go around qualified official immunity. So we had to sue the agency itself and the claims commission on that one. So,
Friends, if you're listening to this, I mean, the one thing that entire scenario just drives home is it's complicated. It really is, and I'm not saying that to cause people to chuckle, but I mean there are so many different layers of this type of law that it just astonishes me every time we talk and you bring up, well, there's also this factor over here, and we may also have that claim. Back in episode 97, when we were talking about filing a claim for pain and suffering, there were several layers of things, including PTSD, which is not necessarily pain and suffering, but it's all kind of wrapped up in there, emotional distress and stuff like this, that
right.
The average person just is unaware, I would think, that no, there are other actions there that you need to consider in terms of damages or seeking restitution for these damages.
Right, and frankly, a lot of times when I talk to people, I have some who are aware of sovereign immunity, and as well, it was the state actor or state employee. We can't pursue anything against the state. No, there's some ways around that, and then there's others who I've had to say, we're very limited on what we can do, because this is if it's a discretionary act and it's Commonwealth of Kentucky, our only avenue may be this board of claims, because they have immunity, and getting around that immunity is extremely, extremely difficult. You can't get around it except having it be found a ministerial act instead of a discretionary act. And sometimes you don't know until you get into litigation, which it is. But those are different, those are things, and having those conversations and saying, look, unfortunately, we got a very limited recovery here, and they're going to get all these things here reduced. Even though they limit it, they also keep limiting and keep cutting from that, and it can make it very difficult, and you have hard conversations with families at times. So.
No, tragic conversations at times. But then again, that's the value of speaking with Jeff Roberts, because he's got 32 years of experience doing this. I mean, Jeff, you've been down the road, no pun intended, but you've been down the road on this multiple times, so you kind of know what to look for. You kind of look for those. Well, this gate may or may not be open depending on the facts of that individual situation. So let's have that conversation. And you give free consultations.
Correct. Yes, the initial consultation with me is free from that standpoint. And yeah, I do have 32 years of experience, as you said, and I don't claim to know everything, but I one of the things I still remember from law school is how to look up things. So if I don't know the answer, I can go find the answer to it from that standpoint. And so, but these are complicated, and the avenue that people originally think when they come in to see me may not be there, but there may be another avenue that they hadn't even contemplated that we can pursue to seek redress for the wrong.
No, that's outstanding. Jeff, you've actually got two offices. You've got the Calloway County office right in downtown Murray, and then you've got the one in Christian County in Hopkinsville.
Correct.
But it's the same phone number, right?
Same phone number. It's 270-753-0053 is the phone number to call to reach me. I do keep the same phone number. The Hopkinsville office is by appointment only. The Murray office is as well. From that, I don't. If you just drop by, very well may not be able to meet with you. I may be in court, maybe have other meetings or whatever. So it's always better to call ahead to get the appointment scheduled from that standpoint. And the best way to reach me is by phone. If you've not called before, you call in and they will talk to you. If I'm able to talk to you, I will talk to you. If I'm not able to talk to you, they'll get information, and we'll either get you set up with an appointment or I'll give you a call back or something. We'll do our best to take care of you.
Outstanding. Well, Jeff, I want to thank you for your time. I know it's a busy day today, but again, just thanks for taking the time to really prep for this and share that knowledge. Because again, the law is a very complicated situation, and we've always endeavored to try to break things down to make it a little bit more understandable, at least, and so people don't make assumptions and assume they don't have a way to pursue justice here or to try to seek some recovery for their damages. I mean, that's a nice thing that you're willing to sit down and listen to it and give them some advice, and whether they take it or not is up to them. But at least you've got 32 years of experience, and I think that advice is pretty solid based on what you've done here.
Well, I appreciate that. Well, and I like one of the reasons I like doing these podcasts is some people just want to know. They're looking at, they may have a situation or a family member and they're just looking for information. I understand that. And that's part of the reason why I do these podcasts is to provide information for individuals to use. I don't give any, I'm not giving any specific legal advice for your specific situation because I don't know that specific situation from there, but some general information that they can use. And then if they think they need more information or they got a situation that they think they do need a personal injury attorney, then they can call me up and set up a time to come in and see me, and I'll be happy to talk to them.
Outstanding. Well, Jeff, once again, thank you for your time. And from the Roberts Law Office, where they deliver small town service and big city results, thanks for listening.
Thank you.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.